Hi, this is Wayne April, member of the Educational Programs team. And today's presentation is on undue influence, which is part of our fraud education series that we're going to be doing. And today we have a couple of presenters, and I think we're going to start off with Nolan Arcos, who will introduce himself.
Thank you, Wayne. Thank you all for having me. For those of you who don't know me, my name is Nolan Arcos. I'm an associate attorney at Lagerlof LLP, where I focus on elder law. And outside of that, I also serve on the board of directors at Pasadena Village, currently in my first term. And it's been a really good opportunity to get to know this community more and just see all the great things that the village has been doing. And one of those things is this excellent program that's being kicked off with today's presentation, where we're focusing on preventing fraud, mostly financial elder abuse. And so I think that's something that's going to be just so important moving forward. It's always been important, but especially now, there's just from an attorney's perspective, there's potentially dismantling at the federal level consumer protections. And so it's especially important that our community stays up to date and informed of, all the different scams and all the fraud tactics that are being used, because the technology continues to get more advanced. So there will be a lot more presentations and activities down the line in the future with this program that focus on a lot of that fraud and those outright scammers. And today's presentation is going to focus on something that hits a little bit closer to home, and that has to do with something called undue influence. So undue influence is just as, it has just as much potential to cause major damage, both financially, but also physically. And so this is something that I think everyone needs to be aware of. And it's also something that has a very vague legal definition. There's a general idea of it, but what I want to do today is equip you with the signs. So that's why I've called it Know the Signs, and it's so that you can walk away from this thinking about, okay, what are the red flags that I look out for, and what do I do when I see these red flags? So we'll start with the definition of undue influence. As I said, it's pretty straightforward if you're thinking about a dictionary definition, which is basically that you are, if you're being unduly influenced, it means that someone else is exerting pressure or force on you, and it could just be simple coercion, and they're trying to make you do something against your own wishes. Now, that's a very basic look at it. When we start thinking about, okay, how does that actually turn into facts? How do we actually identify that in the real world? I like to look at it sort of like a recipe, and you have four main ingredients, which include, first one being the vulnerability of the victim, the second being the influencer, that is, the person who's the bad actor, what sort of authority they have over the victim. The third is actions or tactics used to influence the victim. And the fourth is unfair or improper outcome. So all four of these together, these are the ingredients that make up undue influence. And like any recipe, you might have variations on the ingredients, but at the end of the day, you still need your basic ingredients in place to make it happen. So we'll get into each of these four ingredients now. And again, I'm going to focus mostly on the facts, because that's what a lawyer will be looking at, that's what a judge will be looking at, and so it's important to have all of that in place, so that you can identify it. Because I could talk about the code, I could talk about case law, but that's not really going to be something you can take away as much. And of course, I'm always happy to talk about the more technical legal ideas, but I figured I'd give something a little bit more practical here in terms of the facts that I look for as an attorney. And just a little bit about my background. I practice elder law, so that includes a lot of work involving seniors when they make decisions, whether that's planning ahead of time to say, these are the people I want to make decisions for me, or if that planning isn't there or it fails, going to court to make sure that the decision maker is appointed and that whoever's in charge is acting properly. So I'm both inside and outside of court, and I'm constantly scanning for these 4 ingredients here, trying to see if there's undue influence. The firm I'm at also does a lot of litigation, and a lot of it, when it comes to trust and estates, like contesting a will, a lot of it centers on going after people who may have put their thumb on the scale, so to speak, in terms of creating an unfair outcome. So we'll start with vulnerability. And vulnerability, I break it down into 3 main categories. So the first has to do really with the physiological and mental factors. And this is part of the reason why I brought Dr. Wong into this presentation, because I'm a lawyer. I know about the laws and the rules, but I'm not a doctor, so I don't know about all the ins and outs of a person's physical or mental faculties and how that affects their independence and their decision making. So that's what Dr. Wong will talk on in a little bit after my presentation. But these are some factors to consider in vulnerability when it comes to having a vulnerable victim. And it doesn't necessarily have to be all or nothing. It can be a gradual decline. There can be subtle issues that come up, or it could just be, an unexpected health event that puts someone in a position where they're vulnerable. And so this can affect you both physically and mentally. And you can have someone who has, complete faculty of their mind. They're just completely, they're able to comprehend everything, but they're completely physically unable to defend themselves or resist undue influence because they have to depend on someone for all their care. That person could be unduly influenced. At the same time, you could have someone who's completely physically there, could like run down the street and may not have their mental capacity, and that person could also be unduly influenced. So it can cut both ways, and that's what makes undue influence particularly tricky in a legal context, is trying to prove the health side of things. And so doctors often come in as expert witnesses because that's going to be a big question: is, okay, what was this person's overall physical and mental profile looking like at the time of the alleged undue influence? And then there's also what I like to refer to more as social or sociological factors, the biggest one being isolation. When someone is isolated, that puts them at a massive risk of undue influence. It makes them extremely vulnerable.
Get someone there.
And then on top of
I
that,
have my own Wi-Fi, so.
any sort of language or literacy barriers.
Yeah, Nolan, I'm gonna just take a second to mute everybody.
Oh yeah, no problem.
And then just unmute yourself. Okay.
Yeah, sure thing. All right. So language or literacy barriers is another factor that I see in my practice, whether that's someone who has English as a second language, or maybe they have limited education, or a learning disability. It could affect the way that they read documents, and they could depend on others, just simply for looking at a statement or something. That puts them in a vulnerable position, because now they're depending on someone to make sure that their bills are current, to make sure that, medication is being administered properly. So that puts them in a vulnerable state. And then there's more environmental factors, which include, immediate events that someone might have, some sort of immediate loss or some sort of traumatic event that creates a lot of negative emotions, and that makes someone extremely vulnerable to undue influence. Also, any sort of destabilization in a person's home or their residence. So, natural disaster is a really good example here. You could find yourself completely displaced, and that can put you in a position where you're having to depend on others. So you look at all of these, and any of these factors could create significant vulnerability, and that's part of what leads to undue influence. So we'll move on to the next ingredient, which is authority. So you can have someone who's vulnerable, and most of the time they will need to depend on someone else. That creates authority. So under the law, we usually think about it as trust or confidence, meaning it's somebody who is the victim. They're going to tell this person all the personal details of their life, any sort of personal financial information. That stuff by default is confidential. That's your own personal business. But when you depend on others, you may be in a position where you have to turn over that information. And now suddenly someone has access to all of this. And if they're not upholding their duty to take care of the victim, then it creates even more of a risk of harm. So the first category that we see are people who are close to the victim. This is one of the more common categories of people with authority, and that's any family member, whether that's a child or a sibling, or any partner, whether that's a spouse or a domestic partner, or an informal partner like a boyfriend or a girlfriend. These people, they have all of that knowledge, they have all of that confidential information, and they may not necessarily have the training or the recognition of the actual duties and the liability that forms from any sort of improper action that they take. So that combination can make it really easy for someone to justify to themselves that I'm doing the right thing because I'm taking care of this person, or I'm looking out for this person, when in reality what they're doing under the law isn't correct. So that's the first category we see. The second category we see focuses more on people who have some sort of professional obligation to the victim, whether that's a caregiver, and that could be someone that lives in the house and is there, basically around the clock. It could also be someone who stops by a couple hours a week just to give some help where needed. So caregivers often have that very close relationship, and that's a person who the victim will be dependent on a lot of the time for the day-to-day life. It could also be professionals, lawyers, bankers, accountants. All of these professions are bound by ethical rules, but if those ethical rules aren't followed, there's a lot of damage that could be done because the lawyer knows a lot about the person's finances and their liabilities and everything. So it can make it particularly dangerous. Although rare, it's one of those things that causes a lot of harm. And then anyone with legal authority, the fancy legal term here is fiduciary duty. So that could be someone under a power of attorney, a trustee, if you have a conservatorship in the court system, or maybe like a rep payee for Social Security. That person has an ongoing duty, and they also have a lot of power. So they have to use that responsibly. And then we also see less commonly, but still there's potential, is with people who may have some sort of business relationship or other sort of relationship by circumstance, whether that's a landlord who is handling the property for the senior victim, and they're a tenant, and now you have that threat of eviction. That creates a lot of power. Or even a salesperson going door to door selling things can make a lot of representations and possibly cause a lot of harm that way. The common thread amongst all of these positions is that this person at some point usually gets a lot of access to everything about the victim, whether that's their house, their personal possessions, their documents, and also private information. So we'll look at tactics on the next slide. But one thing about private information is California has a lot of very specific protections for private information. You're not allowed to disclose private information about someone. In California, you could get sued in civil court just for sharing private information. So even the threat of disclosing that private information is major. But again, influencers will use that to create leverage. In terms of what is used, what the influencer might do, obviously the most foundational one, if it's a caregiving relationship, is that they control the basic needs: food, sleep, medicine, personal care. It may not be so obvious up front. It may just be something where they think that they're being disciplined or strict. They just pass it off as that. But in reality, they're causing a lot of harm or threatening a lot of harm. So that sort of control of basic needs that's the first stop that a lot of influencers in that sort of caregiver relationship will use. Another one that I see a lot is lying, especially when it comes to false narratives. Especially when you have a victim who has difficulty exercising, their rational thought because maybe they have a condition like dementia or something that puts them in a position where they have trouble interpreting the world around them, crafting narratives for them and putting things in, a very good versus evil light, simplistic narratives. Doing that can often be something that the victim latches onto because it explains everything in a way that's easy to digest. When in reality, the facts are a lot more somewhere. It's in the gray area between. It's not all one or the other, and a lot of times there's projection there because if there is actual financial abuse occurring and the influencers, taking money out of the accounts, they have to explain that. So why not just pin it on the family members and create distrust against the family members? And in that vein, another tactic is keeping the victim from communicating with the outside world or getting information from the outside world. Any sort of restrictions on there, that's a cause for alarm. Or moving the victim to a new residence or moving in with them. Either of those could be particularly dangerous because now there's complete control over that victim's home situation. It can make it harder to investigate a claim. And then again, going back to environmental factors, when things get difficult, when they're dealing with a medical emergency or a personal emergency or a family hardship, those difficult periods, that's when the influencer will often apply the most pressure because they know they can get a result. So they might use something like affection and intimacy, sort of like the carrot or the stick approach, or they might use intimidation or coercion. So there's a lot of different forms that sort of pressure can take. And it really depends on the relationship between the influencer and the victim. So again, it takes many forms. And a lot of times it's characterized by speed. They're trying to rush the victim into making a hasty decision, usually secretly, so that there's not a lot of oversight on that process. Because the more time you take, the more chance there is that the undue influence can get caught. So as a practitioner, as an attorney, that's a lot of what I do on estate planning is, I try to give it as much time as possible. When it comes to setting up meeting with clients, I never rush anything because I want to make sure that whoever's in front of me and making decisions about their estate plan, that's actually what they want. So I like to give people enough time to think about things and think about whatever advice that I'm giving them. And then again, in line with restricting information and making it harder to track down the victim, changing providers, doctors, lawyers, banks. Sometimes you might see people do what we call physician shopping, where they may go from one doctor to the other to get a specific medical diagnosis. So those are all things to keep an eye out for. And then finally, what ultimately creates undue influence is if there's an unfair or improper outcome. So this can take many different forms. Obviously, the biggest issue would be any immediate damage or loss that the victim sustains. So that could be just straight up cash missing from an account. Another big one is real estate. In order to transfer your property away to someone else, it just takes basically 2 pieces of paper and your signature and a notary stamp. That's all you need. And then once that person has your property, they can do whatever they want with it. They could put really bad financing on it. And then at that point, it costs a lot more to unwind that process. But it's something that often gets overlooked, and it can lead to a lot of issues down the line. But that's one big damage that I've seen come up time and time again. Another thing that happens, and this is what I mentioned earlier when it comes to contesting a trust or a will, undue influence can create a change in an estate plan. The victim goes to an attorney and rewrites their estate plan to cut out people or to include people. And if anything about that looks suspicious, the law says, hey, that creates a presumption of undue influence. Like, we're going to just assume that something's not right here. So that's a big one. And it's tricky because you can't really go after that in court until the victim has passed away and you're administering their estate. There are some ways you can get around that, but that's something that's especially tricky because the remedy is not immediate there. And then any excessive gifts that might be made to the influencer, anything that affects the influencer's house. Again, going back to that landlord as an influencer, any sort of eviction that might happen, that could potentially be a negative outcome that suggests undue influence based on the facts. And then identity theft, either because the influencer is not being cautious with the victim's information or is outright giving up the information. And then, of course, on the physical and mental end, any sort of neglect, whether that's mental or physical. Weight loss is often one that we see in terms of malnourishment, because if food is being withheld, then that could suggest that there's some sort of pressure that's being applied from someone who has that caretaker position of authority. And then also any sort of impact on a person's rights, which is, your right to stay in your home as long as physically possible, your right to marry or divorce, which it takes a lot of effort to take away that right. And even the court will say, someone who has a conservatorship can still choose who to marry or divorce most of the time. And then, of course, medical treatment is a big part there. So when you have all four of those ingredients together, you get undue influence. So the question now comes to who helps here? So the first major safeguard comes through law enforcement, and that's mostly starting with adult protective services. The county will investigate claims of undue influence and elder financial abuse, and then they usually will choose whether or not to refer that for criminal prosecution. So they may take it on to the police or the county, depending on who's involved, and then it'll lead to additional investigation. Now, the challenge is criminal claims, they require much higher amount of evidence. They have a higher, what we call, burden of proof. And so adult protective services may just simply investigate a claim and then close it if they can't find enough evidence. That doesn't mean that you're out of luck in terms of defending against undue influence, because private attorneys can bring other actions more on the civil side to help either immediately protect the victim from further harm, and if there's clear evidence of past harm, to get that money back or to get that property back. So there's a lot of different things that can be done. There's special protective orders, like temporary restraining orders, that are designed to prevent undue influence and keep specific abuser away, especially from a senior. And then also, I think organizations play a really important role here, because they provide resources, and they also, especially like in the case of Pasadena Village, provide something that's very community-based. Having the care team, having these neighborhood groups where everyone is sort of in the loop with one another as to how everyone's doing. When something doesn't seem right, when you're in that sort of community, it's much easier to speak up, and that can often help get in front of these issues. So that's sort of who can help. Now, let's think about what you can do, because I've shared all these red flags, and there are a lot of things you can do. Sometimes it can seem overwhelming, sometimes it can seem helpless, but there actually is a lot that any person can really do if they suspect undue influence. And so let's say you see your friend and it seems strange, and you've checked in on them before. You can check in on them as a friend, try and talk with them if you can, if that's something that they're used to. And at the same time, while you're doing that, you take note of who's there. If it seems like there's a potential person with authority, that could lead to undue influence. So that's something to take note of. At the same time, if there's anyone who has legal authority over your friend, whether under a power of attorney or a trust, if they've ever told that, said, hey, call this person if I ever have an issue, figure out who those stakeholders are. And then, of course, if there's any clear signs, based on all those factors that we saw before in this presentation, if you see any of those clear signs, it may be worth a call to Adult Protective Services. And then, of course, if there's any sort of emergency, then that is definitely something that should be elevated to the police. Also, if someone isn't letting you in, that could also be a potential emergency that could warrant police involvement. And then after you've made that attempt and you've gathered information, if you know who has that legal authority, under a power of attorney or a trust, you may want to talk with them, or any relatives who might be close, who seem trustworthy, sharing with them the facts and urging them to consult with an attorney could help get out in front of that before damage is done, or if damage has already been done, before more damage is done. And then, of course, you want to make sure you document everything, at the very least, just writing down notes, during or after your visit, so that the details are still fresh in your mind. That's usually what I recommend that people do when they're in these sort of situations. And then I'll just provide some resources here. So I've sent the slides to the village, so they'll circulate them. LA County Adult Protective Services, again, when there's clear signs of abuse, you can call that hotline and submit a report. They also have an online form that you can submit for matters that aren't urgent. And then also some local police departments here. For Altadena in particular, that's part of unincorporated LA County. I know that through LA County Sheriff's Department, they have a very robust fraud and cyber crimes bureau, and a lot of what they focus on is elder abuse, especially real estate issues. So that's something to keep in mind if you're in Altadena. And then outside of that, I've also listed some resources here, one being for seniors who may not necessarily qualify for, or who may not be able to afford an attorney. Bet Zedek provides services to seniors, very specifically directed at seniors. And then also Public Counsel does a monthly legal clinic where it's very much designed to help vulnerable populations. The Public Counsel one, I volunteered at that a couple times. It gives you access to an attorney for 30 to 45 minutes, so they can assess and tell you if you have a potential case or not. So those are two things to think about if money's an issue. And then Pasadena Village has helped with Aging SGV's website, which has a good fraud page, and that has a lot of the numbers and information I listed on the prior page with regards to police departments and adult protective services, and then it also has some other links and resources. Overall, just a really good place to look at. And then also AARP has a pretty good page, mostly on more general fraud and scams, and then like I said, this program that Pasadena Village is launching is going to get into a lot of those as well, in terms of helping prevent people from falling victims to scams, because this is something that really I think even I'm not immune to it. I think we all know someone who has a story, whether it's ourselves or someone else who might have fallen victim to a scam or almost fallen victim to a scam. So you want to make sure that while you're thinking about your personal life and undue influence, also what's on the outside there, because you got to be mindful of both fronts. So I think that's it for my presentation. So we'll proceed to Dr. Theresa Wong's presentation here momentarily. I'm going to load up the slides, and this is going to focus more so on the medical side of things.
Great.
So I'll let Dr. Wong take it away.
Thanks. So are you gonna be clicking through my slides?
Yes.
Oh, thanks.
Yeah, sure.
Great. So you guys can hear me okay? Great. So my name is Dr. Theresa Wong. I am a primary care doctor with a specialty in geriatrics. So I only see patients over the age of 60 in my private practice called W Geriatrics. And what I'll talk about today is something very specific in the medical field called capacity and how that relates to medical decision making. And then we can kind of link that together with this concept overall of undue influence. But let me take you first into the medical world and then kind of bring it back out into the overall world of being safe from undue influence. Okay, next slide. So there are 4 key elements to capacity, which means capacity or the ability to make decisions independently. And in this talk at the beginning, I'll talk more about how to make, whether you can make medical decisions independently or not. So the 4 key elements are, number 1, understanding of it. So to be able to say out loud the benefits, risks, and alternatives to some sort of treatment or intervention that the medical team is offering. And not only understanding it, but also appreciating how these benefits, risks, and alternatives really apply to the current situation. So like, how much of a benefit is it? How much of a risk is it? And like whether these alternatives are really applicable. So really to try to get nuance into the understanding, not just recite them off of an informed consent paperwork, for example. And number 3, reasoning, not only based on facts, but also consistent with their own values. And consistency is really important. It really comes down to whether this person's decision really is consistent with the kind of person they've always been. Like even if it's a decision that maybe you would want them to make, but it just does not sound like something they would have done back when you really knew that they were clear-headed, that's a red flag as well. And then the very last element is to be able to communicate a clear choice. So after coming up with the benefits, risks, and alternatives and explaining everything, to be able to say, this is the choice that I want. So we need all 4 of these elements to be solid to determine someone has capacity to make a medical decision. So we'll go one by one. So capacity is different from competence, and competence is more of a legal term when it comes to decision-making in general. Capacity, you can actually click to the next bullet. Capacity can also vary with circumstance, which is different from competence. That's something we sign, and then somebody, it's kind of related to conservatorship. You sign away someone's competence, and it's kind of a global decision. Whereas capacity is situation by situation. Like, for example, somebody with dementia certainly has the capacity to choose whether they want strawberry or chocolate ice cream that evening for dessert, but they don't have the capacity to make a decision about open heart surgery, for example. And capacity can wax and wane in the same person. So somebody who just all of a sudden gets sick from a pneumonia or urinary tract infection, during their acute illness, they will not have capacity. And then when they get better, they can regain capacity. So that's important to note. We need capacity in order for people to sign an informed consent. And then the last bullet, one more click. This is important to note because capacity is not really something that's top of mind for every doctor to be assessing for. When we meet people, we're really giving them the benefit of the doubt, trying to give them as much autonomy as possible. So in order for a doctor to diagnose incapacity correctly, we need to be aware of how prevalent incapacity is in the population of the people that we're interacting with. So in the general healthy older adult population, maybe in a primary care clinic, 2.8% of these healthy older adults probably do not have capacity to make medical decisions. However, that number jumps dramatically from 2.8% to almost a quarter of patients in a medical ward. So if you're admitted to the hospital, the doctor really needs to be aware that fully 1 out of 4 of the patients you talk to probably do not have capacity to be having a conversation about complex medical decisions. And even higher still is patients with Alzheimer's disease. Half of them probably don't have capacity to make medical decisions. That's still actually a little bit maybe lower than what you would expect. There's also the ageist, ableist bias that everyone with dementia doesn't have capacity. So we tend to take away their autonomy more than we should. So 50% chance that they might not have capacity, that also means 50% chance they could. So we need to take the steps to determine capacity before we make that judgment. So next slide. So these are the risk factors. You can click through, there's 6 bullets. So these are the risk factors that Nolan was talking about that make somebody vulnerable to having impaired capacity. So this doesn't mean that you won't have capacity if you have these factors, but you do have to have, as a doctor, you need to be aware and maybe consider doing a formal evaluation if you encounter patients with these risk factors. So number 1 is actually just being afraid of institutional healthcare settings, like being afraid of the hospital, being afraid of doctors, being afraid of nursing homes. That sort of fear and distrust, it just makes it harder for people to really engage and really understand the complexities of medical decisions. So that's something you need to be aware of, not to ignore. And age, the age has a little bit to do with the prevalence of dementia at older age as well. And then chronic neurological conditions and chronic psychiatric conditions, they don't always overlap, they sometimes do. Like a lot of psychiatric conditions later develop into neurocognitive decline, and then some people with chronic neurological conditions maybe will develop some psychiatric condition later on, but they can also be separate. So these are both diagnoses that affect the mind. So something to pay attention to if the patient has this diagnosis. Low education level, unfortunately, like definitely don't want to discriminate. We also need to understand that the way that we talk about medical decisions and procedures and everything in the hospital is often at a higher register than a lot of our patients can understand. So we need to pay attention to the language that we use when we try to explain medical procedures. And then finally, a cultural or language barrier. One common example is about that comes up in our medical exams is about Jehovah's Witnesses and related to blood transfusions. So that might not be like an unreasonable thing to decline a blood transfusion if you understood that there was a cultural difference in tissue transfer. Okay, next slide. So I came up with 3 scenarios that represent some pretty common examples of when capacity comes into play. So one I talked about a little bit earlier is abrupt changes in mental status. So for example, there's a 75-year-old man with diabetes, and somebody else has started to notice, his wife has noticed he's become increasingly confused. He manages his medications himself usually. And then when he comes to the emergency room, his blood sugar is through the roof. And then he's given the treatment for that. He gets better. And then the medical team is asking him to stay overnight for observation, but now he's demanding to go home. So a lot of times in the hospital, we encounter patients who want to make a decision about their medical care, especially regarding admission or discharge. Either they want to stay longer or they want to leave sooner. And then if it's not really matching up with what the medical team thinks is right for the patient, then we start to think, is this a capacity issue? Can this patient really make this decision, considering they were just so what we call altered in their mental status so soon from this decision? So that's one example of somebody who normally has capacity to make all their medical decisions, manage their own meds, and then abruptly kind of lost that capacity. And now we have to determine, are they back to being able to make their own decisions? I'll describe 2 more scenarios, and then I'll go into how we actually evaluate capacity. So the next slide is scenario number 2. So this is a bias that physicians often have. I mean, this case is a little bit more obvious, but a lot of physicians, medical professionals, we have this bias where if somebody doesn't choose a decision that we want for them, then we start to ask whether they have capacity. So, but in this example, there's a 67-year-old man with long-standing schizophrenia and diabetes, stopped taking his medications, and now has a major complication from not taking his medications. And he's saying that it's because he is that the healthcare professionals are controlled by aliens that are trying to kill him. So this is a case of like active, untreated mental illness, a psychiatric illness that is interfering with the person's reasoning for making medical decisions. So this is an example of when somebody's declining a beneficial treatment, then we start to worry. And then the last scenario, scenario number 3, is kind of the opposite. Also, when somebody readily agrees to doing a procedure, you have to think about that as well, especially if the procedure is risky. And one common scenario I see is dialysis. So dialysis is a life-saving procedure. Oftentimes we start somebody on it and we don't really know when to stop it. So in this scenario, 86-year-old woman with advanced dementia, it has been doing dialysis 3 days a week for many years. She's becoming increasingly frail to the point where even to go to dialysis, she needs to be transferred from a gurney, and she's mostly bedbound at home. And then, but when you ask her, do you want to continue dialysis? She says, I'll do whatever the doctor says I should do. So this is, for some doctors, they would just go along with it because this patient's agreeing to what they want to do. But what you also have to think about, even if somebody agrees with you, whether they really have the capacity to make that decision. So next slide, I'll talk about how we evaluate capacity. So there's 6 bullet points on this one. First, we need to sort of set the stage for this evaluation. And number 1 is to rule out all communication barriers. And that kind of reminds me of Nolan's slide about vulnerable adults. So you got to make sure they can hear you, they can see you, they feel safe talking to you, and then making sure that you get an interpreter if necessary. So getting the communication clear between you and the patient. And then related to scenario number 1, you got to make sure that any reversible causes of incapacity are completely treated. They're in their best state of mind. They're as healthy as you can get them. And then, so the next one is more of an informal way to check for capacity. This is what most of us do as physicians, is just to go through those 4 elements and ask questions about them. Like, for example, the first element, understanding risks, benefits, and alternatives, you could just ask, what are they? What are the risks, benefits, and alternatives? Tell me. And then you can ask them, you know, how did you come up with that? Like, can you tell me in this scenario, like, how beneficial is this? How risky is this? And then based on what you know about the patient, or maybe you can kind of check in with their friends and family, like, is this consistent with their values over time? And then make sure that at the very end, they come up with a decision themselves. You can't let the capacity evaluation end on, I'll do whatever you want me to do, doctor. Because that's the 4th element, is communicating a clear choice. There are resources for formal capacity evaluations out there. There's rubrics with questions that are pretty similar to the informal questions, but you can assign points, values, and then add them up. And then that can be a little more helpful if you need, if you're not quite sure you're getting the information you need with the informal questions. Sometimes, especially in the hospital, especially if it's contentious or like a really high stakes decision, we might bring in a second opinion from another clinician. Oftentimes psychiatry gets involved, especially if there is an underlying psychiatric diagnosis. What's interesting is cognitive testing is not always required for a capacity evaluation. Because as I mentioned before, a dementia diagnosis is not like a be-all end-all for not having capacity, because capacity varies by circumstance. So you have to be able to judge, in the context of what the decision that needs to be made, does their cognition matter in the situation? Are they still able to communicate what their preferences are in the moment that's consistent with their values over time, things like that. So oftentimes I get pulled to make a diagnosis of dementia in order to give or take away capacity from somebody. And that's not always necessary because of the reasons I explained. Okay, so the next slide, the reason capacity, there's 3 bullet points on here. The reason capacity is so important is just number 1, ethically. Autonomy is thought to be, you know, like one of the highest values of a human person, of a human being, free will, to be able to make your own decisions. So it's really high consequence for us physicians to take away capacity from somebody. That being said, for someone to make their own decisions, you're trying to prevent them from self-harm. You also want to prevent any unnecessary or unwanted medical decisions, unwanted medical interventions that may be in a state of illness or like mental fog that they might say yes to, that they otherwise wouldn't have. You don't want that to happen. And then in the theme of undue influence, there's also this concern about ulterior motives of the surrogate decision makers. So once you take away somebody's ability to have capacity to make decisions for themselves, you're giving all that power to the surrogate decision maker. So we have to be really wary of that as well. Okay, so the last slide, there's 4 bullet points on here. So when it comes to how to advocate for yourself or for a loved one, I would say, like, my bias as a primary care doctor is for you to establish care with a primary care doctor, and to do that as soon as possible, because remember, the 3rd element of capacity is whether your values stayed consistent over time with the decision that you're trying to make. So to have more people on your team by your side who really know you over time can really give you the best chance of a fair assessment of your decision-making capacity. And along that same vein, if you're able to document your wishes early on as soon as possible in something called an advance directive or a pulse, that gives even more weight to a capacity evaluation because we have prior record of what you would have wanted. And then make sure that you choose a trusted surrogate decision maker. That might not always be your child or your spouse. It could be somebody that you feel like has a good understanding of medical decisions and would understand your wishes. And of course, talk to them about your wishes. And then in terms of advocating for loved ones, really reach out to isolated seniors, especially those who have those risk factors for having impaired capacity, so that if you can lend a helping hand, if they're in trouble, that you can be the one who speaks up for them. And that's the end of my talk.
Thank you so much, Dr. Wong. That was great. So I think we'll open it up to questions. I'd actually like to start with a question, just going for Dr. Wong, going back to that last slide. I think this is a good one. And this is something that I didn't know until, you know, like 2.5 years into law school, but what's the difference between a surrogate decision maker and an agent under an advanced healthcare directive? Like from a doctor's perspective, you know, how do those two come about? Like what's the distinction there?
I always thought that they were synonymous. But when it comes to surrogate decision making in real life, it gets really flexible. Like the advance directive is a legal document. You get it notarized, you have it stored somewhere safe. But when it comes down to business in the emergency room, like whoever shows up and says, hey, I know them, or like, hey, they've talked to me about something, in the flurry of emergency situations, physicians, healthcare professionals, we will listen to that person. It's not great. We don't always get in a lot of trouble for it, because when it comes to saving, like the bias in the healthcare setting is always towards saving a life. which in many cases for older people is unfortunate because prolonging life is not always somebody's goal. So in that sense, as much as you can to have as much documentation on you as possible, to carry your advanced directive or pulse with you, or to have your surrogate decision maker as your like primary call person on your cell phone to be able to be there is really important.
Great, thank you. Yeah, and I asked that because yeah, it's sort of the distinction between theory and practice. Because on the legal side, yeah, that's the theory, is that we have an advanced healthcare directive. But exactly as you mentioned, when you're actually, you know, in the hospital or the emergency room, it gets messy. And like, yeah, if I were, you know, if something happened to me and I'm in the ambulance, even if I have an advanced healthcare directive, I could tell the paramedic in the ambulance, hey, I want this other person to make decisions for me. And now I've designated a surrogate, and that person can make decisions. So when you have you know, disputes between siblings, you know, over, okay, this is what decision we should make for mom, you know, it can get really messy there. So that's why planning is so important, because, you know, it can help make things clearer, especially for end of life decisions too.
I just wanted to interject here. Maybe we could stop sharing so we could see.
Oh yeah, sure thing. Sorry. Yeah, let's go. All right. How's that look? Does that look good?
That looks good.
All right. Awesome.
Anybody raises your hand or wants to have a question, if your picture's not on, then just use the electronic hand raiser. I guess that still works. Does anybody else? Karen, looks like you have a question or a comment.
Yeah, well, this is really a good overview of everything, but it just seems so clean because we had this very situation in my family and it was terrible. And I saw all the signs and I didn't know what to do. And I finally called the elder abuse hotline. I didn't know who else to call. Well, they sent the sheriffs out and they were looking for physical abuse.
Mm-hmm.
And I'm trying to remember my conversation with them when I called, and I never mentioned any kind of physical abuse. I mentioned isolation, inability to talk to my relatives, and I was concerned. The neighbors were concerned, other family, friends were concerned. But what they did is they sent the sheriffs out to check on them. And we all lived in Altadena. And it was my aunt and uncle. And my uncle he didn't know who had called them. But I do know, I heard he was furious that they had been called out there. And I was embarrassed to admit to him that it was me. And but my relatives in Colorado, in Palm Springs, they knew, they were concerned. We were all concerned about what was going on. But finally, when the relatives that did the undue influence got all of the property and moved them out to a family compound up in Arroyo Grande, I wrote my uncle a letter. I don't know if he ever got it, but I confessed to him that it was me that had called and why I was concerned. And, you know, I don't know if they ever received any letters. They were isolated from the whole family. And this went on for a period of well into COVID. My aunt and uncle both ended up dying. It finally went to court. It was litigated. All the documentation, all the emails that I sent were key to the case. And it was so awful to see what happened and not know what to do and thought I was doing the right thing. The only right thing I did is everything was documented, all my concerns. I emailed them to my cousin. I emailed them to the family friends in Palm Springs. We all had the same concerns. None of us knew what to do, and what we did do didn't work. But after all these years, because I think that began in about 2012, and it went to court well, it was a year ago. But the day of the court, the settlement was made, and I think the only reason it was two brothers, and the only reason my cousin settled is because he knew that he probably wasn't going to win the case, and then he would have to be turned over to the district attorney's office. But I mean, all of what you presented is really clear. It makes sense. It seems so clean and logical, but boy, when it comes down to it, it's a damned hard thing to take care of. And my aunt had told me before her son and daughter-in-law came from Texas to visit them, she told me she was concerned about them trying to take over. She told me she was concerned. So we all had the warnings. And boy, once they get in there, it's really hard to do anything.
Certainly. Well, thank you for sharing, Karen. I mean, I think you have shared a really good example here. And again, going to that theory versus practice, you're
Yeah.
exactly right. I can list all the red flags and everything, but you're exactly right. Once you get into it, it gets very messy, and you're dealing with very confrontational, uncomfortable situations.
It was awful. It
Yeah.
was just awful.
Yeah, and the wheels of justice, they do move slowly. You know, as an attorney, I can attest to that. And most cases do end up settling before trial. So a lot of what you're doing is just trying to just get whoever's doing the bad thing to stop and compensate. But the compensation, what, you return the
Compensation is
money?
nothing.
Yeah.
It's nothing compared to the emotional
Yep.
damage that
Exactly.
is done.
Yeah.
There's no settlement that can alleviate that.
Yeah. Exactly. Yeah. And I think, again, that's why it's so important to have, community resources and making sure that we're all looking out for one another, because, a lot of this, if we can try and prevent the circumstances, try and mitigate up front, it can help prevent those issues down the line. But yeah, but thank you so much for sharing.
Barbara?
Yeah, I was following up on Karen's concerns. I had a similar experience with a friend, and even though she had a fiduciary handling her money, that there were people that were working to change her will and get her to change her will. And only because there were friends watching this happen and stopping it, did it get stopped. But I'm wondering, okay, she was protected because she did have a fiduciary.
Mhm.
We couldn't protect her against these people coming in and telling her that the fiduciary was stealing her money, et cetera, et cetera. But if they had, for instance, in this situation, if they had been able to get her to an attorney, which they were trying to do, to change her will and to get the fiduciary, could they have been successful, or is there did she have protection by having had a previous will and having fiduciary?
That's a really good question. And I would say yes. From an attorney's perspective, our profession is what we call self-governing, self-regulating. So, when I became an attorney, I swore an oath to uphold all the rules of court and all the ethical rules. And part of those rules include being fiercely loyal to your client's interests. And part of that, especially in an estate planning context, is identifying and preventing undue influence. So having a prior estate plan in place is really important in that context, because for me, if I ever get a new planning client come in the door and they say, I want to change my estate plan, and they want to do a bunch of different things on it, especially when it comes to cutting out children, or cutting out their natural heirs, that immediately raises a red flag for me. Now, you can have a valid reason to do it, but a lot of times it suggests undue influence, and that's what the law says. It says if
Right.
you cut out your kids, it's unnatural. And so, but the problem is, some people they can attorney shop. So if you have someone with bad intentions, they might keep trying attorneys until they find one that's just willing to crank out a a trust and a will and amend things.
Well, I think they would have found someone.
Yeah.
My question was if they had, and if they had been successful in replacing the fiduciary, at least trying to do that legally. What the fiduciary suggested is that if they had been successful, it would have gone to conservatorship because
I
we did not have, and so, yeah, is there a way that we can protect ourselves by setting up whatever?
Yeah, so there's one possible way, and this is just speaking from more of a general perspective, but when you draft a power of attorney, or just when you can do it as a standalone document, you can nominate conservators. So if you have a document that says in your handwriting, that I want to make this person my conservator, or if it says that in your power of attorney, if you show that intent, that's evidence. That, again, it's not ironclad, but you want to leave as much evidence as possible. Now, when somebody goes in and changes all the documents, it makes it harder to do that. But yeah, so from a planning perspective, making sure that you have a clear nomination. Again, when somebody goes to the attorney and gets the documents changed, it's a lot harder. Now, the conservatorship process is naturally designed to pump the brakes when it comes to fiduciary selection, because when you file for a conservatorship, the court appoints an attorney for the proposed conservatee, and that person will interview with them and ask them about their preferences. Even if this person doesn't have, the competency to make advanced decisions, they may still have the basic capacity to state preferences. So that's sort of a safeguard. And also, whenever you have competing conservatorship petitions, the court will just put all of it out to a trial, and that gives a lot of time to fight over the details. And I've actually had cases like that. I have a very similar case like that where one sister came in and changed all the documents, and we got those documents undone because we were able to show enough evidence to the court that, hey, this isn't what reflects reality in terms of what the person wanted, and then you lay out the circumstances of the signing. So it comes down to the facts of the signing, and if you can show enough, you can get documents thrown out.
But it also sounds as though the fiduciary or the attorney, the original ones, have to step forward and say,
Yes.
Yeah, I can't accept this change.
Exactly, that too. Yeah. So that's what's so crucial, I think, and that's a vital part that attorneys play, is making sure that when someone comes in and they want to change their estate plan, that it actually reflects their wishes, and that they're not doing something that creates an unfair or untrue result.
But I'm talking about a situation where they have an attorney who is willing to do this.
Yeah, and if they do, then it's in court, and you're just fighting it out, and it gets really expensive. So yeah, so that's pretty much the last resort.
Okay, Karen?
I have a question. My aunt and uncle had a good degree of wealth. They had all of their paperwork in order. How the one son was able to change everything, I really don't know. But my question to you, Nolan, is if someone came into your office, a new client, and they want to make all these changes, you said that these are red flags for you. So my question is, what do you do in that situation?
Yeah, so, well, the first question that I usually, well, not question, but the first acts that I take will be, again, I'm not a doctor, but I can ask some basic questions to the client that give me some factual insights as to how they're perceiving. So the standard one that you might see attorneys ask is, what day of the week is it? Who's the president? You just sort of ask these questions to feel out if this person actually has capacity. If they don't have capacity, then you basically have to, make the disclosure to them that you can't represent them and end the representation right there. And if they do have capacity, then at that point, what I do is, I have to walk them through it, and I walk them through it multiple times, and I send it to them in writing, and I tell them, these are the potential downsides of this. And the number one thing that I have to do every time when I'm meeting with a new client is get face-to-face alone time with them in the office.
Yeah,
No
that's-
one else in there, no children. The children can drive them to the appointment, if they need a ride, if they need help, the children can drive, but they're going to wait out in the lobby. I always make the kids wait out in the lobby. I say, it's no hard feelings. I know they trust you, but I
Oh.
need that because, if they're in the room with me and I draft up that estate plan, down the line, if I get subpoenaed and I have to testify, then I have, and if I say that the kid was in the room and was calling the shots, or even just in the room, then it's pretty clear that there's potential undue influence claim there. So I always try and keep people, make it so that it's pure confidentiality there. Yeah.
Well, that's very interesting because Gloria Pitzer is my attorney, has been for many years. But when I have met with her, except for the time when my husband and I were together and met with her, but once I was single, I invited my children to be with me. I wanted my kids to know all the discussion about everything. And I invited the kids to ask questions as we go along, that we would discuss it as a group, because the one thing I wanted to avoid among my children is the kind of bickering that happened with my brother and my sister and I. It was so ugly, and I didn't want that to happen. And Gloria has been very, very pro have the whole family here.
Mhm.
And it's worked out really well. And I just, since losing my home in the fire, recently had another meeting with her with the kids about any changes that needed to be made. It was time for me to update things anyway. And it's been excellent. But I get it where if there's any doubt, you gotta
Yes.
ask for a one-on-one meeting. But these
Okay, I
are
want
my
to
choices.
make sure we give everybody a chance. If anybody else has a question or a comment, since we're running out of time. Sharon, are you raising your hand, or is that just a pinky? Betty Ann?
At the end, yeah.
I was just going to mention, everybody has their stories, but I knew a sister and brother that lived in Altadena, and they got into their 90s. The sister died. Neither of them had ever been married, and a caregiver, not from an agency, was taking care of him. And she took him to Las Vegas and married him. And it was a disaster because he had a lot of money and charities were supposed to get the money. But I'm telling you, because they couldn't prove that he didn't want to marry her,
Yep.
she got an income for life. And the money was supposed to go to Pomona College and the Pasadena Symphony. And they did get some of it, but she was able to get an income for life because they couldn't prove that. It was a mess.
Yeah. And marriage is especially tricky. Like I said, in a conservatorship, that's like marriage and the right to vote. Those two things the court keeps basically sacred. Like unless there's a very clear cause, even if you're conserved, you still get those two things a lot of the time. So and it's one of those things where it's so personal. It's hard to distinguish. If somebody, even if someone's being taken advantage of, they might want to be taken advantage of in a marital context, at least. So, and it's so personal, so yeah. And I've seen some of the messiest cases have come from those sort of relationships. Yeah. And then
I do,
Oh, yeah.
I do want to give Dr. Wong an opportunity
Yeah.
to respond for something. And I want to say that as a former social worker at Kaiser, there were so many times I wanted to get my patients in from the home into the hospital to be evaluated for their cognitive status. And there was no way to get that done because they either would refuse to go to appointments or the caregivers would refuse to give them the appointments. So when I could get somebody in through the emergency room, I would immediately run in there and try to get the doctors to refer them for some kind of cognitive evaluation. And that was always a challenge because it's not the ideal situation in an emergency room because most patients are already compromised when they get there. So the most important thing that I always recommend to people is get a cognitive workup because oftentimes attorneys and families would come to Kaiser and they'd say, they're trying to unravel all the fraud that took place with their relative, and they're trying to figure out when the point came when the relative didn't have capacity. And you do forensics with the charts and whatnot and so forth, but it's very difficult to determine when somebody didn't have capacity.
Yep.
And when they started giving money away or having money taken away, were they in their right mind? And it was very frustrating without a formal cognitive evaluation.
Yeah. And in a conservatorship context, you can't get a conservatorship unless you have this very specific court form filled out by a doctor. So yeah, so it's always going to be up front there on the legal side too, if you want to do anything when someone loses capacity too.
Dr. Wong, do they call you into the emergency room for things like that, or is it do you have privileges at the hospital?
No, I chose not to have privileges in a hospital. So what I do now, I do house calls for my patients. So I've done a lot of rapid cognitive evaluations for people in the home who can't leave their home.
And do you submit those to their medical record, or?
Yeah, I'll document it for myself, and then for legal purposes, I'll write a letter that summarizes my impressions.
Mhm. Okay, well, just be aware that they may end up in court as the primary documents for somebody's fraud case.
Hmm.
So it's important to be as specific as possible. But there's an attorney, apparently in California, I had a friend who I was trustee for, and he lost his cognition. And he had a hired caregiver that was basically, excuse me, convincing him to change his will. And unfortunately, the power of attorney was his cousin, who was a very, very unworldly man. And he tended to believe everything the hired caregiver said. So anyway, they brought my friend into the his attorney that he'd had for years, to change his will, to make his hired caregiver the primary beneficiary of his estate. And I didn't go in the room, the cousin did, but it's my understanding that the attorney, this is what the cousin told me, the attorney asked him a few basic questions and determined that he had capacity. And I was like, I was expecting that the attorney would refer him to a doctor for a cognitive workup. But no, he said, I'm allowed to do that when I talked to him later about it. He says, I'm allowed to do an in-office evaluation and determine whether the person has enough capacity to sign documents. And so he went ahead and changed the will, making the hired caregiver the primary beneficiary, dropped a bunch of the other beneficiaries. And the only thing he did, I guess, to cover himself was to give me the final decision on whether the caregiver was still involved with the patient enough to become his primary beneficiary. So, and it turned out the case went to court because I said he wasn't involved because I had fired him, and he ended up getting a sizable chunk of the estate anyway because it went to arbitration.
Yeah.
So I was very disappointed to find that out because I thought I had all the power.
Yeah, and that's what's so tricky too. Again, settlement. I mean, anything can happen in mediation and yeah, all that informal negotiation. I mean, yeah, it's crazy. You can have someone who's completely in the wrong and they can walk away with something. Just because nobody wants to go to trial, which I don't blame people for not wanting to go to trial because it has a major financial toll and also an emotional toll. It's a lot. It's a long, arduous process. It's very emotionally draining for all the participants. So and that's just sort of the reality of the situation. And that's part of why vast majority of cases settle. So.
I just really wish that I look back on the situation as it was unfolding and I just think, what could I have done differently? And I mean, I had no idea how bad it was going to get.
Yeah. Well, Karen, the thing too is sometimes it sounds like you did a lot. Like I said, you already followed the
Well,
advice
the
that I
key
gave,
was the
documenting.
key was really all the emails that I
Yeah,
sent. That was the
exactly.
key.
Yeah, documenting everything is important. And sometimes there's only so much you can do. Sometimes just the way that things go, like you know, we always think about what we could have done. And again, as long as you're behaving reasonably and you're trying your best, you know, that's the most you can do in some situations. And then, you know, there's a sort of, unfortunately, there's a certain amount of stoicism that at least in my practice I take on, which is, you know, I look at mitigation. You know, what can we do right now that we're dealing with this issue? Yeah. And then to your earlier point, yeah, I know Gloria Pitzer. She's great.
Fabulous.
Yeah. So yeah, and then also for me, I do bring the family members in sometimes, again, after, you know, that back and forth of, are you sure you want to involve them? Like, I have to make sure you're in here, because I do think it is, especially when family members are on good terms to start. You know, I think it's important to have some of that involvement. You know, if there's not a lot of potential for conflict, just because you know, it just helps keep things more in the open. You know, but it varies.
I
from
just
family
want
to
to keep
family.
things transparent so that nobody can say, well, that's not what you meant. Well, that's not what I heard. You
Yeah.
know, I just want to
Yeah,
keep it transparent.
for sure.
Does anybody else, Betty Ann?
Just quickly, I was just gonna give you one other story. A gay man at the Quaker meeting left all of his money, and he had a lot of money, to the Quaker meeting. And his family, he didn't have any immediate family. His distant family, who had always rejected him because he was gay, got in there and said, that's not fair. We want the money. And to your point, they do give preference to relatives.
Yep.
So they ended up dividing the estate, but I think about half of the estate went to the family that hated him, and the other half came to the Quaker meeting.
Yep.
Wow. Terrible.
It seems like the law's on their side.
Yeah, the law favors heirs. I mean, it's and it ignores the fact that heirs can, you know, be terrible people sometimes, just as much as any stranger. So, yeah, it's and that's part of why it's so important to have a good estate plan, because if you have a trust drafted in a way where it clearly lays everything out and you've left contemporaneous evidence of your intent, that can help prevent those sort of claims from coming up. Yeah. All right. Do we have any other questions, Wayne?
Yeah. Does anybody have a question for Dr. Wong?
Thank you to both of you. It's a great presentation.
Barbara?
Yeah, I was wondering if either, Dr. Wong or Nolan are mandated reporters. If you are required by law, as the other people are, to report abuse, and would undue influence be included with that?
So I'll start first, and then I'll turn it over to Dr. Wong. So for me, as an attorney, I have to protect my client's confidential information at every peril, meaning I can't really disclose anything. The ethics code does allow me to make a disclosure in a very limited situation, which is basically if someone's going to get seriously hurt. I can make that disclosure, but it's at my own discretion. So I'm not a mandated reporter like under the federal law. And most of what I have to do is keep it confidential. But, you know, thankfully, because of the way that I draft documents, I can include authorizations to a person. If somebody comes to me for a power of attorney, I include in that power of attorney an authorization to have me represent their agent and contact their agent down the line. So if somebody comes to me or I see potential undue influence, I can now reach out to that person, the victim's agent, and say, hey, this is what's going on. They've authorized me ahead of time to talk with you. Here's what, you know, I recommend you engage with us or some attorney and do that. So there's very specific ways that you can include safeguards there, but I don't have anything that's mandating me to disclose that to anyone. It's all kept confidential.
Dr. Wong?
Yeah, so I am a mandated reporter for child abuse, elder abuse.
Is that physical only, or if an undue influence situation came up,
Typically, we describe it as physical, psychological, or neglect. Yeah, that's a good question. If I was noticing some financial abuse, if I would be required. Most of the time that I've reported is some sort of like medical consequence of abuse.
Mhm.
I
Thank
guess,
you.
yeah, that does bring up the confidentiality thing for doctors. How do you make like an APS report without violating the confidentiality of their medical record?
Yeah, the APS reports that I've submitted, they don't ask for too much detail. It's just the patient and then what kind of abuse I'm worried about, and then they send their representatives to do the investigation themselves.
I didn't realize when I worked at Kaiser, the doctors always referred APS reports to the social worker. They didn't want to deal with it. So, well, that's good. Any other questions? Final questions? We've pretty much run out of time. Okay. Well, thank you very much, Nolan and Dr. Wong. You did an excellent job.
Thank you so much. It's been a pleasure presenting.
Yeah, thank you all. I hope you learned something new.
Yeah, always.
Thank you.
Okay, well, thank you very much, everybody.
You want to stop the recording, Wayne?
Yes, I will stop the recording if I can find it.
Appreciate you all coming. Great to see you, Theresa,
Yeah.
Nolan. Thank you.
Of course.
Where is the button?
Great job, Wayne.
Oh, there it is. Okay.